is said to be the best of disinfectants. This mantra of transparency and good governance often resonates within institutions across the world. In today's episode of ThePrint SoftCover, we will be talking about a book that, according to me, intends on bringing in more sunlight into the corridors of the Supreme Court of India, which is often touted as one of the most powerful courts in the world, exercising jurisdiction over 1 billion plus people. The book that we will be discussing is titled Court on Trial, a data-driven account of the Supreme Court of India. As the name suggests, of course, the book uses empirical data to diagnose crises within the Supreme Court. It identifies some very crucial, often controversial areas of concern within the court's functioning, looks for answers in the data, and then offers practical solutions for reform. I've gone through the book and I was just telling the authors that it's a stunning account of the functioning of the Supreme Court, something of the sort that hasn't come out ever before. And I have with me 3 authors of the book: Aparna, Chandra, Associate Professor of Law at the National Law School of India, University, Bengaluru; Sital, Kalantry, Professor of Law and Associate Dean at the Seattle University School of Law and Director of the India Center; and William H.J. Hubbard, Professor of Law at the University of Chicago Law School. Welcome to the show, Aparna, Sital, and William, and thank you so much for joining us today.
Thank you for having us.
Let me first unveil the book for all our viewers. I have it with me here, nicely packed. Trying to remove the cover carefully.
This is amazing because
the book
first check
for all our viewers to see. Love the cover as well. Now, just to start off, I will throw this question to all 3 of you. Tell us about the book in your words. Tell us how this idea took shape.
Maybe I can get started on that question. So this idea took shape with Ted Eisenberg, who was one of the pioneers of the study of courts, and particularly the data-driven study of courts around the world. And Ted had been to India. Ted was interested in doing this kind of work in India, and he and Sital, who were colleagues at Cornell at that time, got started. They got me involved. Ted unfortunately passed away at the beginning stages of this project, and William came on board, and that's how the project started. But that was with respect to how the project got going. What drove our interest in the court was this real puzzle that this is such an important court. I mean, we say we end the book by saying that this is actually the most important court in the world. Whether it is the most powerful court or not, it is definitely the most important court in the world, because no other court exercises jurisdiction over so many people and affects their life circumstances in so many ways. But there really isn't this kind of an overarching account of the court. It's for all the legal scholarship on the court, we actually know very little of the everyday working of the court, right? And that was the puzzle that we were trying to solve in starting in starting this project. I don't know if the others want to jump in here.
Yeah, do you guys want to add anything to that?
So from the perspective of the knowledge about the Indian court globally, and particularly in the United States Legal Academy, I felt that there was such a dearth of information. Clearly, as Aparna mentioned, even within India, there is, we haven't been able to get under the hood, so to say, of the court, and this data allows us to do that. But what we hoped with this work was to also raise global awareness to say, what can we learn from the Indian Supreme Court? One example where the knowledge of the Indian Supreme Court is relevant is in the debates in the United States in the reforming the US court, right? We've had Biden, who empowered a commission, who didn't really look at the Indian Supreme Court except for the testimony and evidence that I submitted, which is helpful because the US Supreme Court is thinking about having term limits, thinking about increasing the size. And that's exactly what the Indian Supreme Court did. It does have effectively, a 6-year rotation off the bench and a larger size. So I think globally, this book for me was a way to help inform the world about what's happening with one of the most important courts in the world.
Right.
I'll just jump in and say a little bit about how this project was so exciting for me. As an American scholar who primarily studies the United States courts, to have the chance to work on the Supreme Court of India and to explore the data about the Supreme Court of India really offered all of the exciting opportunities that Sital just mentioned in terms of what American scholars or scholars of American courts can learn from the Supreme Court of India. And I should add that what was very exciting to me as I began working on this project was discovering that in some ways the Supreme Court of India has more to offer in terms of data. From a pure data point of view, there are more cases, there are more bits of information online about the Supreme Court of India than there are about, for example, the United States Supreme Court. The question was how to collect that data, how to actually use that data to gain insight into what the court is doing. And that's really what our project was about. We were able to find multiple ways to collect different types of data about the judges, about the judges' rulings in different cases, about the administrative data that the court had collected, and brought all of that data together and analyzed it in the book. And that was a really exciting process for me, and something that I think revealed a lot about the Supreme Court of India.
Right. Like you mentioned, there is, of course, a lot of data available online, but at the same time, Aparna and Sital also mentioned a dearth of information in a way. And that brings me to my next question, where the book also initially itself, it talks about how for far too long conversations around on the Supreme Court and its reform have centered around impressionistic accounts or just anecdotal evidence, right? Rather than robust data-driven diagnosis or solutions. But for an institution that wields so much power, there's very little quantitative research on the court's functioning as well. I wanted to put this question to you as to, did you consider why is that so? And do you think the Supreme Court's own efforts in this regard have been lacking in a way? Do you think the Supreme Court lets enough sunlight into its own corridors?
I should say that there are some accounts and some very rigorous data-driven accounts on some aspects of the functioning of the court. We have also relied on that work. Some of the reasons for why we don't have that kind of data on the working of the court might have to do with the nature of the Indian Academy more than the court itself. Lawyers are generally not trained in data science. Data scientists generally find the court and law very puzzling institution as such. And so I think that's one reason why we haven't seen these kinds of accounts. The other is, as you've mentioned, the courts themselves have not made it very easy. The documentary practices of the court now enable us to gather that data from the court. So for example, one of the data sets that we've constructed has scraped all the data available on individual cases from the Supreme Court website. That's over 1 million cases in the time period between 2000 and 2018. Now, this wasn't available to researchers even a few years ago.
Yeah.
So now that that data is available online, we can make use of that data. But beyond that, what we've had to do is very, very time-consuming, methods of collecting data, which is to hand code cases, to read cases and hand code them with a large team of coders, and that's very time, labor, and resource intensive. Which makes it very difficult to do projects of this sort. Now, I'm guessing with the advent of AI, with some of this data now proactively being put available, or at least the information being out there from which we can gather data and quantify that data, I think we are likely to see more and more of these kinds of projects. But yeah, so some of this was only to do with the availability of this kind of information in an easily accessible format. Having said that, of course, the code doesn't make it easy to gather data on itself. Not only in terms of the information out there, but why it makes the kinds of decisions that it makes. And in fact, that's one of the large themes underlying the project, is
Yeah.
that this is in many ways an unaccountable court, unaccountable for its administrative decisions, right? So how does the Chief Justice, as master of the roster, allocate cases to benches? We don't know. Why are certain cases listed out of turn? We don't know the answer to these questions. That really is the puzzle that we are trying to understand through the use of this data.
Right, right. Sital, William, would you guys like to add anything to that?
So I think the unique facet of this book is that we have written it in a style that's accessible to the larger English-speaking Indian audience. And currently it's English only. What I wanted to do was, part of the problem is where there might be some academic studies using rigorous data, they are not read or accessible to a non-academic audience, right? The academics are speaking to each other. Our methodologies are very rigorous, thanks in large part to William's expertise in data and analysis. But we don't focus on that. We've sort of put that in the back, and we've had many other articles that we've included that. So we wanted it to be not only someone who doesn't need to be an economist or a quantitative person, but someone who doesn't even need to be a lawyer, right? So we give you the history of the court and how it started and give deep context. So that's one thing that maybe makes it seem that it's something that is new or unique.
Right. I wasn't planning on doing this, but since you mentioned that you've tried to make the book more accessible, I couldn't agree with that more, because it reminded me of this little snippet that you started your chapter 3 with, where, just to read it out for our viewers, it says, a senior advocate filed a special leave petition with the Supreme Court, and at the admission hearing, a judge asked, "Is there any merit in your case?" He answered, "Your Lordship, I flew all the way from the UK to appear at this hearing. I would not have done that if there was no merit." The SLP was admitted. I think these are the sort of things that, I felt personally that made the book more accessible. There's a bit of humor, there's explanation for everything. You haven't infantilized your readers, but at the same time, you made sure that you explain everything that goes in the book, which I think I understand about, making the book more accessible. William, would you like to add anything to that question?
I'll just say, thank you for those comments. And I think one of the important lessons for myself as an economist and a lawyer working on this project is that if an idea is important and if an idea is relevant, it should be an idea that we can all talk about. It shouldn't just be something discussed among economists or just among lawyers. It should be something that everybody should be talking about and everybody should be able to understand. And the goal of the book is to do exactly that, to take these important ideas, these relevant ideas, and express them in a way that hopefully all of us can join together in a conversation about this Supreme Court of India, the most important court in the world.
You're right, that makes a lot of sense. Now, let's move on to a few of your findings in the book. One of the chapters titled "People Like Us, Diversity or Lack Thereof in Judicial Appointments." Now, it ends with the line, "The Collegium, however, may not have enough internal incentive to achieve more gender and caste diversity on the court." I just found the line really interesting. Now, tell me about your findings in the chapter as well, and also the reason for why you think there isn't caste and gender diversity in the Supreme Court so far. In the sense that, do you think it has been to some extent this lack of incentive within as well?
So, one of the things we just wanted to look at was, if you look at the data and look at the numbers, right? If you compare it to obviously the Indian population, or compare it to even the current lawyers. There isn't, or even comparing it to the judges in high courts, that's where they get many of their appointees. They don't prioritize, in our data when we looked at appointees, they don't prioritize women when they know that that they lack enough women, right? Over time, there's only been, I don't know, a small amount of women, even though maybe it's the highest number ever right now, but it's still significantly small overall if you take a look at the history of the court. So the point is that because it's so little sunlight on the court, as you say, unlike the more of the political branches that have more transparency, and there's been more of a push in the Indian society to have more gender equality, have more caste representation, the Supreme Court is insulated from that. And in a way, the courts should be, right? We want our courts to be insulated from political conversations. We want them to apply law. We want them to be unbiased. But very rarely but they're now utilizing, very rarely do courts appoint their own members. So any court in the world, we haven't really heard of that. Any major court, important court, actually, I have no evidence of any other court doing it. So when they do it, and it's in secrecy, right? It's in the collegium. Maybe there's some minutes that they release, but we don't know why. One of the things we don't know is why certain people are selected. Why is it this one's better than that one? In the US, yes, we have huge hearings, but we at least vet out the individual. We understand why this person has been nominated. So that's what I mean about not having incentive. We just don't know who. It depends on, largely, what 5 men think and who they're going to appoint in any given time.
Aparna, would you guys like to add anything to this?
Oh, I'll just add that, in that chapter, one of the questions that we had in mind was, over the history of the Indian Supreme Court, there was a transition from the president selecting the judges of the Supreme Court in consultation with the judges, the Chief Justice of India, to the current system where the judges of the Supreme Court, a select group led by the Chief Justice of India, have essentially complete control over who becomes future judges of the Supreme Court. And you might think that change in the selection process, by making the court more independent in that way, might have some effect on the diversity of the court. And what we saw in our data, it surprised me at least, was it didn't have an effect. The court had very little diversity in terms of gender and caste under the old system. With the arrival of this new system, it may have increased judicial independence, but as Sital said, it didn't impact the diversity of the court. And what we saw was a pattern that looked very much like a group of men, almost entirely men, and high caste men, who would select individuals who looked very much like themselves. And this is something that one sees in many instances in many parts of the world. But in this context, that's the pattern that we observed in our data.
Right.
I will just add to say, and I don't think that we have the evidence, our data doesn't speak to it, but I don't think we have the evidence to say that it has necessarily increased judicial independence as well, as we've seen in the controversies over the last year. Of course, this is after after the data in our book, but we've seen over the last year the concern about whether this system itself is has increased judicial independence or not. And I think one of the reasons why there's been so much of a controversy about appointments, one reason why it's so easy to have controversies about appointments, is because of the opacity of the system, right? Which means that people can feed in all sorts of narratives into why some judges are appointed and some judges are not. There might be actually very good reasons why some judges are appointed, others are not, but we don't get to see that. And where we do see, I mean, while we do see demands for transparency, obviously this is you also see, for example, the government asking for transparency on the one hand, but feeling offended when the court becomes transparent and releases its reasons for why it has reiterated its recommendation.
Right.
So transparency is and lack of transparency is also a convenient cloak behind which both judges and the government can hide to play, to give effect to its own agendas. And it requires us to just then trust the system to deliver just outcomes, right, or to fair outcomes in terms of who is appointed. And again, one of the themes underlying the book is that for a court that wields immense public power, it should be an accountable. It should be accountable rather than rely on us to trust it, right, and to trust its administrative processes. And this is one of those places where we feel that relying only on trust in a system which has not shown that it is necessarily trustworthy is possibly problematic.
Right. I mean, all this talk of transparency is sort of bringing me to my next question, which is the master of the roster controversy, which also was centered around the whole issue of transparency. Your book touches upon it. One of the chapter begins with a flashback to the unprecedented press conference by the four Supreme Court judges back in 2018, which gave rise to what we call the master of the roster controversy. Now, the judges, of course, felt that cases with far-reaching consequences were being assigned by the Chief Justice of the court selectively to certain judges of his preference. What does your study find? Does it sort of validate these concerns? What did it find about this?
So it does validate those concerns. In fact, it finds that these concerns are relevant across the board. So these are not individual instances. The way the press conference was framed, it appeared as if there were a few instances,
right,
where the master of the roster power had been used to assign some strategic cases, some strategic people. We find that this concern actually is true across the board. To just give you a couple of pointers, the Chief Justice of India in the entire period of our study from 2015 to in fact up to 2019 has been on the bench of a constitution bench, so 5 judges or more, in about 88% of the cases. Which is not a feat that is equaled by any other judge, right? So the second senior most judge, so the senior most judge after the Chief Justice is about 4 times less likely to be on a bench as compared to the Chief Justice. So the Chief Justice has a disproportionately allocates cases to himself, and I say himself
it's not seniority because the second senior most judge,
right, and seniority has no role to play, again contrary to what the judges press conference seemed to suggest,
right,
but the seniority doesn't have a role to play. So the Chief Justice is disproportionately and almost always on these constitution benches, but also the Chief Justice in this entire period has been in the minority only once. Right. And what does that say? In fact, other studies before us have found that I think from 1980 onwards, the Chief Justice has been in a minority in a constitution bench cases. I mean, we count them on the fingers of one hand, maybe 3 or 4 times.
Right.
What does that mean? If the Chief Justice is disproportionately assigning the most controversial cases, which is what these constitution bench cases are, to themselves, at least they have an outsized say in these decisions, which no other judge can equal. At the same time, they can always carry the majority with them. That seems to suggest that the Chief Justice, who has the power to decide who gets on these benches, is picking judges who are likely to side with the opinion of the Chief Justice. So that is a concern that we find again across the board. Again, and it's like I said, this is a theme running through the book. When the system has been challenged, the court has said, trust high constitutional functionaries. And the question that we ask is why? Again, in a democratic system, we should be focusing on accountability and not trust.
I'll take up the chapter on post-retirement jobs of judges. The book touches upon the trend and concerns on judges pandering to the political branches. Do you think a solution also, and in the book doesn't look at it, I want you guys to tell the readers, to tell our viewers about the findings, but also, do you think a solution sort of lies in looking at the sort of post-retirement jobs taken up by judges? So just to ask, are some post-retirement assignments more, let's say, acceptable than others?
So in our investigation into this question, we relied on some excellent work by other scholars. And I just want to note that although much of what we report in the book is our own original research, we had the benefit, as Aparna mentioned, of excellent work by many other scholars that looked at smaller aspects of the overall question, but nonetheless very, very important aspects. And in this chapter, what we found in the studies that had been done was really compelling evidence that the possibility of being able to obtain employment after mandatory retirement at age 65, when many judges on the Supreme Court are still going strong as legal functionaries. What we find is a tendency among those judges to vote in ways that might be seen as pandering to the government, as saying, "Look, I'm on your side." Again, all we have is their voting patterns. That's what it appears to be. We don't know more than that. But if that's the appearance, then it certainly casts doubt on, as Aparna put it, the sense that trust in the institution has been earned. Now, how does one address that in thinking about the post-retirement jobs that might be available for judges? There's different ways to think about it. And again, our book simply seeks to pose these questions without claiming to have all of the answers about how to resolve them. One thing I'll just note, though, is judges currently are not allowed to practice law after they retire, and so there are two ways to think about the types of jobs they might have post-retirement. One is to say we should restrict those jobs more so that they don't take jobs that might create incentives for them to vote one way or the other. Another possibility is maybe place fewer restrictions on the jobs that judges can take after retirement, on the theory that those options may lead to less pandering. Now, that's a tough question about exactly how to approach one or the other, and the answer might be not to even think about what jobs they take, but what other steps might be taken in terms of the length of tenure, the availability of retirement income that might reduce the incentives for judges to feel compelled to take jobs after retirement. I think there's a lot of potential directions that reforms could take.
Right. Aparna, Sital, anything to that?
So yeah, I would just say, that in the 1950, and when the Constituent Assembly was designing the court, the Constitution created the court, right? It created it with a certain polity in mind, a certain size, didn't anticipate where India would be today. And I think that it is time to and there's been really not significant institutional changes. Maybe the size of the court has grown. That's one way they've dealt with increasing litigation and backlog, but haven't really thought about other ways to deal with that crisis, being more cautious about the cases they take, rather than sort of being this, a people's court that's wide open to business for many people. So I think these institutional changes and reforms is at a critical moment in juncture, especially with the 75th anniversary coming, for the court to think about, some of which they can do internally, some of which requires Parliament and to be part of it. But I hope that our book opens that conversation within India.
Yeah, one of the comparative points that Sital's comment reminded me that we should probably mention is the extent to which the Supreme Court of India is an outlier among many high courts around the world in terms of the age at which judges are required to retire. And then another thing to think about is the fact that many other countries that do have retirement ages, like India does for its Supreme Court, set a higher retirement age than India does.
Right.
I will just add to something that Sital said. If you look at the Supreme Court in 1950, it's a small court, right? It's a court of 8 judges. It is seen as, while on the one hand, it has this new jurisdiction, a fundamental rights jurisdiction, which is new and it's seen as very a central part of the court's role. On the other appellate side, it is seen as a replacement for the Privy Council, right? Some cases will go up to the Supreme Court, but the high courts will generally, decide cases. Unless the high court certify that a case is important enough, it won't go to the Supreme Court. But there'll be some residual power available with the Supreme Court to take up some matters. Now, this residual power, the SLP, the special leave petition, has grown in size so that it is no longer this residual exceptional power. It is the bulk of the case docket of the court today. The court, as Indian readers will be very familiar with, the court reinvents itself in terms of its role in the polity in the late 1970s, early 1980s, or at least it says that it does, right? It wants to be more accessible. It wants to be more open to people from all over the country, people who have otherwise been excluded. It starts this PIL system, so on and so forth. But so there's lots of intentionality in how it sort of shifts its role. But there hasn't been this kind of an intentionality in terms of designing the processes of the court to respond to this shift in role, right? So you take that small court of 8 judges who are mostly sitting on bunk, deciding mostly constitutional matters, a few appeals, and now that's grown exponentially because this role is seen as changed to entertaining a huge swath of matters, large number of appeals. The court size has expanded to 34, etc., etc. But we've not rethought intentionally how these administrative processes and how the other institutional processes of the court should change to accommodate this new role. And that's what a large part of our data is geared towards answering that question of how, if you want to live up to your best impulses, right, which is that you want to be an accessible court that gives fair and just outcomes to people in ways that matter for their lives in a timely manner. How do you reform the institutional processes and the administrative processes of the court that you can actually deliver on that? Because right now, what you have is a court that is working at cross purposes with itself.
Right. I see all 3 of you have now spoken about institutional reform, and that's what I want to ask you next as to, now you've highlighted concerns, you've gone through hard data, the book presents solutions that can be implemented, and all 3 of you have, I've known that, observed the Supreme Court and the judiciary in the country for years now. In your experience, what do you think about the pace of reform within the judiciary currently?
Maybe I can start with that. COVID has definitely brought about some changes, and it's actually anticipated some of the reform measures that we suggest. So, for example, we note that historically India has had a strong emphasis on oral advocacy as the predominant way in which advocacy takes place in courts, and documentary practices in advocacy are more limited and muted. And now we've seen those changes come in, at least in constitution bench decisions, where there are time limits, where there is a focus more on documentary practices. And I mean, I think we suggest that these are the kinds of recommendations, these are the kinds of practices that should take place across the board. We've seen live streaming coming in. We've seen, again, online hearings, hybrid hearings. So there is a huge change that is taking place that might not have been court driven but circumstances driven, but the court has responded. I think there is space now and I think there's general consensus um, at least in the legal community, but I think more broadly as well, that something needs to change. And I think the best evidence of that is that every Chief Justice comes into office and that first interview that they give is
Right.
always court reform, right? But very often nothing really materializes. So the effort here is to put together hard data to say, okay, here is what reform might mean for you. Here's what reform might not mean for you, right? There's some suggestions of reform on the table that the court is considering very seriously that might make no sense. And we, for example, look at the National Court of Appeals, which we don't see anything in the data that suggests, or in fact, the data suggests that it may not help. Right. So that is really the effort, that if you want to engage in court reform, then that has to be evidence-based court reform. It cannot be based on this one case that happened before you that you saw, and that shapes your entire worldview of what the judiciary should look like.
Right. Sital, William, would you guys like to add anything to that?
Well, I'll just echo something that Aparna said earlier, which is that when we talk about the opportunities for reform or the need for reform in the court, we're not taking the position that anything about the mission of the court necessarily needs to change. Nothing fundamental about what the court is trying to accomplish needs to change. This is an institution that historically has been tremendously admired and very popular for much of India's history. It is, however, an institution, as Aparna put it, and as we talk about in the book, working at cross purposes with itself. And in order to identify a path forward for reform, one needs to diagnose where that contradiction is in the court's own approach to its cases and to its mission. And that's what we're trying to do in the book, is to say, if you are a people's court, this is a new way to approach being a people's court. Maybe you don't have to take 10,000 or 15,000 cases every year and decide them in a way that puts tremendous pressure on the judges who are, in fact, essentially unable to say much about any one case because there's simply so many. Maybe there's a different path for being a people's court, taking fewer cases, but setting out guidelines, setting out rulings that may provide a clearer path forward for all of the thousands of courts in India that themselves are also trying to dispense justice.
Right. I think on that note, we've reached the end of this episode. Thank you so much for joining me, Aparna, Sital, and William. The conversation has, I think, I'm sure it will be helpful for our viewers as well, because like Aparna said, we've all seen Chief Justices come. We've seen several Chief Justices come and go, speak about reform, but probably this is the first data-driven account that might help them, address concerns that have been highlighted over and over again through maybe anecdotal evidence or one or two cases here and there. But this could maybe lead to data-driven reform that the judiciary has been waiting for. I'm going to hold up the book once again for our viewers. This is the book, Court on Trial. For our viewers, thank you so much for joining us. Do let us know in the comment section what you thought about this episode. And thank you so much. Do follow us on social media.